Okay, good morning, everybody, and thanks for attending this morning session. According to the program that I have from Thierry, the first speaker in the morning is Doaa ELYOUNES. Doaa, I hope I am pronouncing correctly your name. Doaa is a young researcher. Doaa is a young researcher in legal issues related to artificial intelligence. And she is presently with UNESCO. Correct me if I'm making an error. And so Doaa, you have the floor, please.
Thank you very much. Good morning, everyone, and thanks for having me. Let me share my screen. I need please a permission to share the screen.
Celine or Olivia, I think you have to authorize, as you did yesterday.
Again?
I will need to share screen as well.
Yes, I'm sure. I think Olivia, who is the owner.
No, it's a Celine. Celine. So Celine, can you manage? Can you fix this problem?
Yes, please? I will. It's auto share screen.
Okay, let me try again. Host disable screen sharing. Maybe I'm not, I need to be, I don't know, a co-host or something, I don't know.
It is sufficient that you declare all of us as host.
I can't.
Yesterday, it's Olivia that did that.
But I don't have any more the possibility to do that.
That's strange. Celine?
Yes.
Can anybody else try to share their screen and see only if it's my problem or
No, it's the same for me.
Yeah.
I've got disabled as well when I tried. Has disabled participant screen sharing.
It's Celine, if you are the owner of the meeting, it should be the green button at the bottom.
Okay.
In which you can authorize if you click on this green button, you can.
Or maybe you click on our name and then it should tell you something like.
Yes, maybe it's okay now.
Okay, let me try. Oh, yes, it works.
Okay, great.
Yes. Okay. So let's start again. Doaa, you have 30 minutes.
Okay, I think you see my slides, right?
Yes.
Okay. So good morning again, everyone, and thanks for having me. I will talk today about an important aspect of fairness and explainability, because it's an aspect that links a lot of the requirements from algorithms together, and it's the human in the loop aspect. So the way I will proceed is that I will start by giving some background about human in the loop and about street level bureaucracy, because I will present 2 case studies from the field of welfare automation that will help me to link together the theory of discretion and the impact that the algorithms have on the discretion of street level bureaucrats. It will also help me to illustrate the importance of the symbiotic and collaborative relationship between the human and the algorithm. So the importance of human in the loop. In the past, it was very kind of common to try to create algorithms that mimic the human behavior and aim to replace them. But now the most successful algorithms are the ones that actually help human and not replace them. This is particularly important in the public sector domain because it's such a sensitive domain. And also, there has been a change in the way that we perceive automation compared to the past. There is also a change in a way that we perceive the role of the street level bureaucrats. So the street level bureaucrats are the officers that used to work directly with the individuals and helping them with the different services. And they're being more and more replaced by different algorithms. In the past, the street level bureaucrats had very little power over what they can do, and they were perceived as kind of officers that are supposed to just do what the higher level bureaucracy is telling them. With time, this role also changed, and they've got more and more power to be part of the decision-making process. And this also increase the question about their discretion, how much they should be given discretion to help in deciding the decisions and whether this is a good kind of discretion or whether it leads to like a bias because it's too much diverging from the law in the books. So the issue of discretion and automation is being discussed by very many different disciplines. Of course, public policy. Michael Lipsky is the kind of the father of the theory of street level bureaucracy and the role about this change that I talked about from the traditional street level bureaucracy to the more kind of new and advanced one. From the legal perspective, there is a huge debate about the divergence from the law in the book to the law that is made by human, and the discretion in a way what kind of legal provisions can and cannot be automated. In computer science, we have the whole field of human computer interaction that is also relevant for this field. So I hope that the contribution of my paper and my work here would be to link between the different disciplines and will help me now with the case studies that I will demonstrate to show how it is important to maintain certain human in the loop and to ensure that the discretion of the officers is sufficient and meaningful. So the first case I will discuss comes from Michigan, from the state of Michigan in the US. It's in 2013, the Unemployment Insurance Agency contracted with a private vendor to buy an algorithm that helps with the automation of unemployment, the detection of fraud in unemployment benefits. The goal was to reduce the cost associated with the detection of this unemployment fraud. So they purchased Midas, this automated system. Midas replaced a 30-year-old IBM system that was helping the officers before. So Midas replaced 400 caseworkers that previously were conducting a lot of interviews with the individuals in order to assess if there is any suspicion of fraud. The way it works is that Midas sifts through a lot of data. It analyzes the data. It detects the cases that are at high level of suspicion to be fraudulent. Midas sent automated notices to the individuals, asking them for more information. And if the individual doesn't reply, or if the individual replies and Midas detect that the reply is not sufficient, the algorithm has the prerogative to automatically cut the benefits from individuals and charge them with a very high penalty and penalties and fines. The accuracy rate of Midas was not high. Many people were falsely got impacted by Midas. Their benefits were cut. Many people had to declare bankruptcy because of the high fines that were imposed on them. Others preferred to plead guilty to offenses they didn't commit, just to end the misery as fast as possible. And there are even some cases of suicide that are linked to the way Midas operated because of the pressure that they put on individuals. There are 2 ongoing class lawsuits against the Unemployment Insurance Agency, one on the federal and one on the state level. The next case study comes from location that's a little bit closer to us, from the Netherlands. And now we are talking about the Ministry of Social Affairs and Employment that built SIRI, System Risk Indication. SIRI assists fraud examiners, and it doesn't replace them like Midas. But they are not, SIRI does not only detect unemployment fraud, but all types of welfare fraud. SIRI has access to 17 types of data coming from all different ministries, and it analyzes them basically, and flag those that are more suspicious, so similar to Midas. After any case has been flagged by SIRI, the case can be put under surveillance for a period that can go up to 2 years. And then a risk report is being created. SIRI has some process of checking, like for false positive. For example, if someone, they were receiving some housing benefits, but they were not living in the house, or many people like that were kind of receiving housing benefits that are registered to the same address. So there is a kind of like a small, quick process for checking for false positive, like checking that this is not like a place for housing for people that are in need. So it's normal that many people will be registered to this address. After that, a risk report is being created, as I said, and passed on to the relevant agency for further investigation. So the person that no kind of benefits are being cut before a human has a chance to look at the case. But the accuracy rate of SIRI was, like Midas, very low, and it made a lot of mistakes. This algorithm was also brought into court in The Hague, and the court decided that the use of SIRI is illegal and the government should stop using it, mainly because of privacy-related arguments, which we can get to in the future, later a bit in the presentation. But anyway, the algorithm was suspended. So, as you can tell by now, there are many reasons that led to the failure of those algorithms. One of them is lack of human discretion, but not only. Some is the bad algorithmic design and the very high accuracy rate, the very low accuracy rate that I talked about. And also, lastly, the comfortable socio-political context that led to the rise of such algorithms. And the last aspect is an important one that I would like to kind of focus on a little bit more. So in the case of Midas, in Michigan, unemployment benefits are paid only for 20 weeks, the lowest amount of weeks in the US, the state with the lowest, that pays benefits for the shortest amount of time. And any penalty for fraud in unemployment benefit can go up to 400%, the highest interest rate among all the states in the US. 93% of cases that Midas automatically executed were reversed on appeal. So that demonstrate exactly the high problematic operation of Midas and the bad accuracy rate. In Siri, it's a little bit different. So the Siri was implemented only in poor neighborhoods in the Netherlands and poor cities. So it's not a mandatory project, it's a national project, but the city, the municipality decides if they want to implement it or not. So it's been implemented, as I said, again, in only very specific and poor neighborhoods that end up where mainly immigrants live. It's also a part of a trend. It's not a standalone project. It's a trend of the government to kind of automate a lot of this welfare kind of detection to go after the detection of welfare fraud. And it's part of an international phenomena that the UN reporter Philip Alston, reported on that in a report from last year entitled The Digital Welfare Dystopia, because many countries are using those algorithms for kind of doing good in kind of quotation marks, and for, of course, we all want the taxpayer money to go to the people that are in most need of them. But this is kind of like a cover-up for trying to go after the ones that are the poorest in society. So it's important to keep that in mind when we analyze, how humans are involved in this operation and how the human algorithm relation work. So now, after I discussed the cases in details and gave you a bit of background behind them, I would move on to discuss the theory of discretion and to assess how can we determine if there is sufficient and meaningful room for discretion. So let's start with sufficient room, to examine if there was sufficient room for discretion in both Midas and Siri. The first question that we can ask in this regard is, what is the type of system that was used? Midas is a system level bureaucracy. It is a narrow system. It automated only one type of fraud in unemployment benefits. And Siri is a large scale bureaucracy. It automated many types of fraud all in one system. There are no evidence as which one is better, system level or large scale bureaucracy. And large scale bureaucracies are often associated with e-government projects, and the reason for many failures of e-government project is the fact that it's a large scale bureaucracy. It's a complex system that links together many kind of small systems. So if there is an error, it's hard to go back and tell what part of the system exactly caused this error. System level bureaucracy might seem a bit more favorable because they are easier to understand, but they are also harder to scale because they usually operate on a much smaller scale, and they don't have the benefit of several agencies coming together, discussing and working together in order to improve the services on a higher kind of level. Okay, the second sub-question here would be, what part of the process was automated? So Midas is a decision-making algorithm. It automated the whole process from beginning to end. And Siri is a decision-aiding algorithm because it only automated the part of the final decision-making. Because welfare automation is such a sensitive domain, here it is a little bit clearer which type of system we should prefer. And of course, it should be decision-aiding algorithms. Third is the automated task, a rule or a standard. So here I go to the debate among legal scholars about what kind of provisions can be automated and what kind of decision cannot. There is a common perception that rules are easy to automate because they are clearer and they are kind of a closed cases where you know exactly how to automate them. And standards are harder to automate because they are broader and have more room for discretion. The thing is that both Midas and Siri automated a set of rules and standards. You would imagine that in Midas, it should have been clearer because there should be a clear kind of classification in the law as what is considered a fraudulent case. But when we look closer at the law in Michigan, we see that in order to determine that fraud has been conducted, we need to prove credibility and intent to commit fraud. How to automate something like intent is a very hard task that an algorithm could very much struggle with. Siri is, yeah, of course, has also rules and standards in it because it has both a complex kind of set of different types of fraud that each one of them has different rules or of when fraud is being committed. Fourth sub-question is the discretionary power that is being delegated to the engineer and the technology. So we have the 4 stages of the life cycle of the algorithm. There are kind of like different ways to talk about the different stages in the life cycle of the algorithm, but a common kind of classification is to planning, the initial stage where we ask if AI should be at all used, and kind of laying out the stage that should be taken, data engineering, modeling, where we kind of put everything together and build the algorithm, and testing and maintenance. It's not easy to separate each one of those tasks because, for example, testing and monitoring should always be there, not just at the end. So now let's see if we can identify where exactly the discretion of the people went in those 4 stages. So this was the hardest kind of question to focus on because, as I said, it's not easy to differentiate between the 4 stages and the 2 clearly. It's not easy to find documentation about exactly how each stage was conducted. But if we can look at some examples, for example, in Midas, for the data collection, it's not clear what kind of data actually Midas accesses other than, records from the government. It was that opaque of an algorithm. And for the modeling stage, it's not also clear how the discretion of the 400 employees that the system replaced was kind of built into the algorithm to begin with. And for Siri, again, in the data engineer, if we look at the data engineering stage, as I said, Siri has access to 17 types of data from different governmental entities. Some of this data has nothing to do with welfare, like police records. So this was also a question that the court kind of discussed, and the critics against Siri. Why do you need access to so many types of data that are not even irrelevant to what you're looking for? And also for the modeling, nothing is revealed about how the system works. This is another thing that the court criticized, that even for the intelligence agencies in the Netherlands, some kind of details about the operation of the algorithm has to be revealed. And here we all of a sudden have nothing. So to recap this question about the sufficient room for discretion, we can say that both algorithms have some room of discretion left in them at the end of the day. Of course, in Midas, the room is much, much narrower because the whole process is being automated, and Siri leaves more room for the discretion. In Midas, the room was kind of created actually after the story about it broke down in the media. So the UIA said that, okay, we are going to have back some of the officers to work on Midas and to give the individuals some answers, but we don't know whether that actually happened and what is the role of those new officers. So after we concluded that there is some room for discretion, now it's time to discuss if this room is meaningful. So the first kind of sub-question to focus on the meaningfulness is to examine the human algorithm interaction. Both Midas and Siri gives a very determinative result, fraudulent or not fraudulent, yes or no result. So this is a very kind of definitive answer that does not leave a lot of room for the public officers to intervene. If it was, for example, a scale with different kind of scores, even if the public officers will intervene, they will have to have more than I just agree or disagree with the algorithm. So the explanation would have to be more sufficient, more meaningful. Second question is, at what part of the process the officers can weigh in, their discretion can weigh in. In Midas, it's not clear if at all, probably only if the case arrived to the appeal court. And in Siri, it's true that the final decision is taken by a human, but this is only happen after a certain case is already put under surveillance, as I said, for a period that can go up to 2 years. So discretion can weigh in, but only at the very end of the process, where I think every individual that will be put on such a surveillance for such a long time, we can find something to say about them. The readiness of the institution to the automation. For Midas, there has been cosmetic changes that were added, as I said, after all the media backlash, like adding few officers to support, but not clear. And in Siri, there is a special unit that was established in order to coordinate between the ministry and all the municipalities that are working with the ministry and implementing this project. Last one is the involvement of the street level bureaucrats in the automation process. So as I said, in Midas, it's not clear how the knowledge of the 400 employees was formulated into the algorithm. And in Siri, it's a national project, and it's been built nationally, the algorithm, but the implementation is very decentralized. So the officers who were doing this task before were coming from the regional offices, and those were not, the type of officers that built the algorithm in the national level. This is a bit interesting because Siri in the past started as like a small scale project, like a regional, on the regional level. It was not called Siri, it was called something else. And it also had a lot of error rates. So if the factor is being built, more locally, it does not necessarily mean that it will be better and the discretion of the officers will be more meaningful. But certainly here, there was no significant consultation with the officers who were actually doing the job before. So another way to determine the meaningfulness of the human in the loop is to assess how the human in the loop is impacting other safeguards against automation. Because human in the loop is not the only one. As I said, as we know, we have fairness and transparency and explainability, and they can all be impacted by the degree of human discretion. So in the case of Midas, the other safeguard that is kind of more, that is very significant is due process. And Midas infringed on the right of individual to due process, because people were not able to sufficiently meaningfully appeal the decisions taken by Midas if they are not being explained to them, and if they don't know what is the reason for the cut of the benefit. So because there is no human explanation, due process is harder to fulfill. And we can find a very good examples for that in the case of Grant Bauserman, because Bauserman is someone who got hurt by Midas, and there he was eligible for unemployment benefits. They were cut all of a sudden. And the reason it was cut is because Bauserman got a bonus from the employee to the bank account. So Midas detected that as a fraud, even though the bonus was for the period that he was working. So Midas thought that Mr. Bauserman is back to work, even though it was not the case. And it doesn't matter how many times he tried to explain that this is not a bonus this is a bonus that should not be counted against him for the unemployment benefits. It was not possible for the algorithm to understand that, because this case was just not foreseen in advance. So it was not coded properly in the algorithm. Siri, it's a little bit even, there are more safeguards to be considered. So the court did not examine the case through the GDPR. Most of the examination was through Article 8 ECHR for the privacy. I mean, the court did talk about the GDPR, but not in a kind of full-fledged analysis, article by article from the Article 5, like the item by item for the data protection. We have transparency and accountability here that are completely undermined because of the operation of Siri, and proportionality and data minimization. As I said, the 17 kind of types of data that has been considered, and with no clear, so the court said that there is the principle of data minimization was not respected here because of the amount of data that is being collected. So to conclude, I hope I convince you that discretionary street-level bureaucracy is a vital step for the smooth operation of the democratic society, and is not a second best choice. We often talk about discretion, in a very kind of like negative way, on automation as being a very kind of good and neutral way to work against bad discretion, but we in this process forget also the good aspects of discretion. In order to balance between the two, it's important to maintain meaningful and sufficient room for discretion. And these are the steps that I kind of outline on how we can detect if the discretion is sufficient and meaningful. Thank you very much. Look forward to the discussion.
Okay, thanks very much, Doaa, for this lovely presentation. Really interesting. It's had a number of thoughts while we were talking, but I will move on to Lilian Edwards. Lilian is professor at Newcastle University on law and society, and she's very well known for several publications she did on the subjects we are talking about. So Lilian, you have the floor. 30 minutes as all the other ones. Thank you very much.
Okay, can you see my slides? Okay.
Yes.
Cool. Okay, and you can hear me, right? Thank you for inviting me here today. I'm afraid I wasn't able to get to the presentations yesterday, so forgive me if I am repeating things that people have already seen. My understanding was that I was asked to speak about the current proposal for a comprehensive artificial intelligence act or regulation in the EU. I'll try to pull out and emphasize some of the points actually that have just been raised in the previous presentation, which was very interesting, that reflect directly on issues of explicability, transparency, and accountability. But I'll also try fairly swiftly to give an overview through the whole process of how the AI Act works, because I think you need to understand that to understand the problems with it, because it looks very, very good on first brush, but then begins to look less good, okay? So my idea is to give you this brief summary, highlighting some points that might be particularly germane, then to try and raise what I see as some of the really, really pressing problems about the AI Act, which for me, as someone coming from the UK, which is now sadly floated off from the EU, which is what the picture shows you here, my worry is that the AI Act is being shaped by restrictions of EU constitutional law very largely, and perhaps EU practice, which are not relevant to the rest of the world, and which nonetheless, this AI Act is very likely to become a global model in the same way as the GDPR has become, despite having these flaws. Okay, so that is my current worry that I'm talking and writing about. So I've actually left this not on full slideshow because that means I can see some people. Is that okay? So here we go. Yeah, summary. The proposed EU AI Regulation or Act announced in April, great furore and excitement about it. The first comprehensive position in the world on regulating AI as a whole. We expect several years of wrangling between the various actors in the EU institutions involved. The race is really just beginning here. There's been a long wrangle as to which committees would lead on dissecting the Act in the EU Parliament stages, and that's quite important because it represents battles between the people who are only thinking about economic internal market matters and the people who are more concerned with civil liberties and fundamental rights. And the initial decision that's just come out is in fact a compromise where there's going to be a joint lead between the Internal Market Committee and LIBE, who deal with civil liberties. The Council, which is the Council of Ministers has just brought out a draft proposal to amend the original proposal, which is not in any way binding. It may all not go through, but it's quite promising to me as someone interested in this as an instrument to preserve and promote civil liberties and fundamental rights. It's sort of drifting more in that direction than I imagined, really, or hoped so far. So it won't be enforced for a few years if it happens. It aspires very clearly, very explicitly to become a global standard. So the influence here is not just in Europe, right? And we are very, very interested in it in the UK, for example. The influence, which I think I also have on the next slide, is also very large because the GDPR, the General Data Protection Regulation, though extremely influential and has been picked up by probably over 100 countries by now in some shape or form, is limited to regulating systems with that process personal data. Okay, and that is by no means all systems. For example, you might have systems that deal with aggregate populations and yet have a very strong societal impact. Yet it cannot be said that they are regulating the personal data of individuals. So this goes much further than the GDPR, which is important. I won't go through the extraterritoriality point for the non-legal audience. It will be a bit dull, but this is another reason why this proposal is very significant, because it won't just affect the people producing, coding AI in the EU. It will affect anyone who wants to put onto market in the EU their AI services or products. And that is probably just about everybody, right, in the age of the internet. So really already you are seeing a de facto grab for being a global regulation, yeah? And there is this race going on, which I think we're all aware of, right? There's a Chinese model of AI for good that seems to be based on good for society, but maybe not so good for individual rights. There's a USA model, which is emergent really in the post-Biden era. And there is an EU model, which I'll come to, which majors on fundamental rights. And the EU has got in there and has now got first mover advantage, as it were. So it's very interesting politically. Okay, so the aim, as I say, of the proposal is to protect fundamental rights while balancing them against the pro-innovation agenda, of course, you know. So in the US, you have this idea of permissionless innovation. What the EU is trying to do is create a balance that will still promote innovation while protecting fundamental rights. An important point that I've just written in listening to the previous speaker is many of the legal rights we see right now, people discussing a great deal. I mean, I spent 2 years of my life discussing the right, whether there was a right to an explanation in Article 22 of the GDPR. Very much look at solutions, due process rights, challenges in relation to existing systems that have been built that are problematic, like the ones we just heard about, like Siri and Midas, right? The key idea behind, as I understand it, the AI Act is to try to get systems right ab initio, to try and build them right from the start. That's what it's all about to a large extent. So not just post factum challenge and accountability, but ex ante compliance by design with fundamental rights. So that's really quite a big paradigm shift, which I found very exciting, right? The scope is important. What do we mean by AI? You know, I mean, it's a buzzword, it's hype, it's snake oil. At the moment, it's very wide. Okay, so it includes machine learning, but it also includes logic and knowledge-based approaches, rule-based approaches, decision trees, which, as I understand it, is what Siri does, for example, that it's an old-fashioned logic-based system primarily, as opposed to a machine learning system. So it's a very, very wide scope. But having said that, what you then find is that the actual effective scope is much more narrow. So I'll come on to that. So this is the triangle which you keep seeing in any discussion of the AI Act. It describes itself as a risk-based approach. Now, I have problems with that, which if there is time, I will get to. Okay, but the idea of the risk-based approach is that there isn't just a blanket set of rules for all AI systems, which, as you can see, have already been drawn very, very widely, because it was felt that would be unduly burdensome and would restrict innovation and stop startups getting into the market and everything if everybody was subject to a huge pile of rules, right? So instead, what they've got is this risk-based approach of kind of 4 baskets of risk. And at the top, the red triangle, you have unacceptable risk, which are things that we feel are so unacceptable for society that they should just be outright prohibited. Now, this is more rhetorical than actual. There are very few examples. There are only 4 examples in that category, and at least one of them has so many exceptions. That's the biometric surveillance, that it, you know, it's not that it might as well not be there, but it's extremely partial. Okay, so I'm not going to talk much about them. High risk is where it's at. Okay, so there is this high risk category, which is subject, as I'll say, to compliance with a set of really interesting rules or standards. I think that discussion about rules or standards is very interesting, okay? Then there is another category of limited risk, which again is hardly worth talking about. This is 3 systems they've picked out quite arbitrarily and said they should have enhanced transparency obligations. It adds very little to what's already there in the GDPR and could actually be harmful. And then below that, you have this minimal risk category where there aren't any new rules put in by the AI Act at all, right? There's a suggestion that there be self-regulation by codes of conduct. Now that includes most the AI that most people encounter in their everyday lives, right? It includes content moderation. It includes profiling and targeted advertising. It includes search engine activities. Yeah. So, you know, another problem I have here is, you know, the fact that nearly everything people encounter in the commercial world is actually in minimal risk right now. So let's look. I'm not going to go through all this in the time I have available, but this gives you some idea of these lists. So Annex 3 is the list I'm really pointing you towards here, if you can read that, which is this demarcated list. It is a list. It is not a set of criteria for systems that fall into high risk. Okay, there are also a number of products that incorporate AI systems, which are already regulated by EU consumer law, and they also fall into high risk. That's less controversial. This is where the action is at. You know, what should be in here? What should be the extension of the compliance? So what am I talking about for compliance? Well, if you are a high risk AI system, then I'm just looking at my time, where's it gone? Then what you have to do is you have to certify that you are compliant with this set of stuff called the essential requirements, which are in Articles 8 to 15 of the proposed AI Act as it stands. Now, this is probably the part that this audience is most interested in, okay? So this includes that you have to manage and document your risks. You basically have to, this is a bit like an impact assessment. You have to look at the risks for the life cycle. You have to look at them according to intended use, which is, you know, something I could talk about for a long time. Do AI products have intended uses? What about general purpose AI? What about large language models? Do people then use them according to their intended use? Often not. They get used off label. You know, a surveillance system for seeing who buys what products in a shop gets picked up and appropriated for, you know, surveillance of ethnic groups in public spaces. You know, so we see a lot of that, right? It gets hacked also, which is a problem. So anyway, that's one of the rules, is that there is to be this assessment really of your risks throughout the life cycle of the AI, and you're to pass that down to future users of your product, by which the Act really means future deployers of the product. Yeah, when it uses user in this very odd way to mean someone who takes an AI system and puts it into operation in, say, their workplace, right? Coming over here, we have some really important provisions, which actually I'll just skip to the next slide and talk about in more detail, okay? So this is what probably this audience might be most interested in. What does it say about how we're going to be building high-risk AI in future to make it comply with the kind of qualities we'd like to see, like being transparent, like being challengeable, like being explicable, like containing aspects that will control error, the kind of error rates we saw in Siri, right? Or in MyDAS. So this all looks pretty good, right? You know, again, like many people, I was very excited when I looked at this. So the training set data, for example, is to be of high quality, right? This is Article 10, which has changed its name a few times, but it's basically the data quality article. So the aim here is to build systems in such a way that they combat the ability of AI to inherit historic bias, to create new types of bias, to be error prone, etc., right? So it's looking against error, bias, discrimination. And it asks, for example, that you look at all of the data that you use for training and also the data you use for testing, which I haven't got there, and that data be relevant, it be representative, so representative of whole populations, not just of like, you know, 21-year-old students whose data you had in your database, or just white males, you know, that you use to take your pictures for your face recognition database. Okay, it's meant to be representative, and it's meant to be free of errors, which at the stage we're at right now, people are saying is completely impossible, and they're pushing back on that. And the data's got to be complete. So, you know, so that brings up again the kind of paradigm problem that comes up, which is face recognition databases, right? Which are full of white male celebrities and not full of, say, women of color, right? From different ethnic groups. And then there's really technical instructions here, incredibly technical instructions for a piece of legislation, particularly from the EU, which tends to legislate in quite high level principles. You know, that it's got these really technical mandates that you have to pay attention to things like the labeling of the data, the cleaning of the data, how you enrich the data, how you aggregate data from different sources. So all of this, you know, looks pretty good, looks like it's following best practice. Transparency has just been mentioned. Transparency is specifically required. This goes perhaps a bit further than the GDPR in that it's saying high-risk AI systems shall be designed and developed in such a way as to ensure that they can be transparent, right? Which is an interesting formulation. Again, how possible is that in a real machine learning system? This relates to Article 14, which is pretty novel, it goes a lot further than the GDPR, in saying that systems are to be designed in such a way that human oversight is possible. And, you know, I've just labeled that this minute actually as a due process formulation, right? You can't challenge it if a human can't see what's going on and can't stop it. Yeah. So this is that systems are to be designed and developed in a way such that they can be effectively overseen by the person who then runs the system. So if someone builds an automated hiring system in the US, say, then they've got to, theoretically, if they want it to be imported into the EU, build it in such a way that the person who buys it in the workplace, who knows nothing about computer science and just uses this to try and hire people, that they can, for example, be aware of automation bias, you know, that they shouldn't over rely on what the computer tells them, that they should be able to correctly interpret the output, which seems to imply that, you know, it should be built in such a way that people can analyze statistics, you know, the fact that your population might not represent the norm. They should know when not to use the output of the system. So all of this seems brilliant, but very aspirational to me. And one of the things I want to do is talk to computer scientists about just how possible it is. And I've just added there that there is a particular reference to accuracy and that systems should, and remember, these are meant to be mandatory rules, achieve an appropriate level of accuracy. Now I've now got about 8 minutes left. No, I've got a bit more, haven't I? I've got about 13, yeah. So what will I say? So that looks great, right? That's the good bit. But the but is, how do you prove it? How effective is this? What's the enforcement mechanism for making providers of AI systems go through all these hoops, do these very onerous things to conform to the essential requirements? Well, I am so not going to go through this. I just want to show you that the Act, when you look at it, looks incredibly complicated on this, on the various enforcement and assessment and audit bodies and processes that are involved. But what it really comes down to is this slide. Okay, so when you go through all these hoops, what you actually find is that for your Annex 3 high-risk systems, right, which are things like employment systems and systems that manage essential public services like welfare benefits, like assessing if children are at risk, like assessing tax, like looking for fraud, also credit scoring, certain private services, certain policing activities. You can go back and look at that list, but lots of really important stuff. For all of these, really, you're mainly going to be self-certifying that you conform with the essential criteria, okay? The only exception to that really in that Annex 3 list is the use of biometrics by both private actually as well as public sector. And even then, that is quite likely, if the right standards are made, to resolve to being self-certification, okay? So all those important systems, mainly you're going to be saying yourself, yeah, I did it, you know, and forgive me if I am healthily skeptical about this. The second problem about this is that this conformity, this certifying that you are in conformity with the essential requirements is mainly going to be proved by following technical standards, of which I'm sure people are very familiar. So like BSI, in my country, BSI standards, ISO standards, standards from IEEE. In this case, the standards that are going to be set up are going to be created by two EU bodies called CEN and CENELEC, which you may be familiar with. I wasn't before all this. This is following a model which was established in the 80s called the New Legislative Framework. And that worked quite well. The idea of that was to certify the safety of products like toys and dishwashers and cars and model planes, you know, all kinds of things like that that consumers encounter, right? Machinery. And to make sure it was safe. We've probably all seen this. So the idea of the NLF framework is that people who produce products like that, say toys, have to conform to the relevant standard for their industry, which is usually intensely technical. So, I mean, I've seen some of these, and it's things like the copper wire shall be this thin and shall not be longer than that. And, you know, if the dishwasher goes through the spin cycle twice by accident, it shan't reach a higher temperature than this. So there's no danger to consumers, right? So it's very technical. So you can understand within that framework, the model that this is established by certification with technical standards, which are made by technical standard setting committees, okay? The question is, how valid and responsible is that as a framework to put towards checking whether AI products, systems, services are conform with fundamental rights, with issues like bias and accuracy and error, and whether they discriminate against vulnerable minorities. This is all stuff that these standard setting bodies have never had any experience with. And, you know, anecdotally, this is not my own evidence, anecdotally, these bodies, though I'm sure intensely responsible, are made up of people from industry, and also that they are heavily lobbied by industry, which is another worry, right, as to whether these standards will fully express the desire of the Act to bring in these standards like transparency and accountability and explicability, right? Again, another problem here is, will civil society representing users, actual users, you know, citizens, data subjects, be able to get involved in this standard setting process? And as things stand, that's very, very dubious. At the moment, what happens is there are 2 civil society bodies that have rights to attend. Only one is really relevant, and it's called ANEC, and it knows about kind of consumer rights and so forth. Other people, how are they going to get involved? You know, EDRI, Access Now, EFF, all the people in the world that want to be involved in this process, they're not there. They don't have the money. They don't have the technical resources. It's going to be extremely difficult for civil society to get in there and perhaps combat the move here towards technical conformity, which ignores rights issues. I'm ignoring the next 2 points because they really don't matter. One good thing is that there is going to be a register of AI systems in a central database, and that will be all AI systems, not just high-risk AI. And that will be good because it will mean it will be for the first time visible, for example, what AI systems government is actually using, you know, because at the moment that's all been gathered by private knowledge by people like Algorithm Watch. So it will be tremendously useful that at least for the activists and the civil society who want to go and look at these systems and try and find out, as we did with Midas and Siri and lots of others, you know, whether they are breaking these rules and whether they are breaking basic tenets of the ECHR and the EU Charter, for example. So what else shall I say? I've got about 2 minutes, is that right? Something like that?
You still have 5 minutes.
5 minutes, okay, I'm trying to think what to say. So there is some post-marketing enforcement. It's very weak and probably not worth talking about. Let me go on to some more of these points that I've just been bringing up, okay? So this is the slide where I was going to summarize a few of those points that I've already been throwing in. These are all my problems. Okay, there are quite a lot. Lots of them are based on the fact that they started with this product safety model because it was there, it was lying around, it was easy. They had the institutions in place. They knew about technical standards and technical standard committees. But when you look at it, it's really inappropriate for this. So for a start off, why have we just got this arbitrary bucket of systems that are in prohibited AI and that are in high-risk AI? And, you know, most of the debate that's going on is actually centered on the prohibited AI because it's sort of sexy. But for me, the real issues are actually about trying to implement those high-risk AI systems. So why don't we have contextual criteria for what's a high-risk AI system? Why are we stuck with this arbitrary list? Why have we adopted this model drawn from product safety? Because part of the problem with that, if you look at the next bullet point, apart from all the problems I've already mentioned, is that if you take a system that was meant to make people who made toys make sure that their toys were not defective and wouldn't blow up in the faces of children, right? That's what the original system was meant to do. How do I get rid of that? Stop. Then the people who know how to fix it are the manufacturers, right? The person who makes the toy knows what's in the toy. He knows if the toy has asbestos in it. He knows if it has a defective battery in it. So all of the duties are on the manufacturers, which in this act turns into providers of AI systems, the people who make the system upstream. But as I think very many people here will know, that's not what AI is like. AI goes through a life cycle. You might have somebody who creates an algorithm, which then gets picked up by somebody else and turned into some kind of upstream machine learning as a service in the cloud, which then gets picked up by a commercial provider, which then gets sold to a local authority or a government body. And it's only at that last point in the AI Act scheme that the system becomes high risk and that kind of scrutiny cuts in, which is too late. And we know that many of the harmful impacts in terms of rights, in terms of bias and discrimination and, you know, interference with autonomy and all sorts of things will only come in the context of use, which can't really be anticipated by the upstream providers. So it just doesn't capture the risks that arise through the life cycle of AI. I've already gone into this point quite a lot. Why are we letting technical committees make rules about fundamental rights? I've already mentioned this, which I don't know the answer to, which is, can these wonderful essential requirements actually be done, or is this all rhetorical? This is a big point. If you look at the GDPR, it's very much based around the human rights, the right to privacy of the user. So it has a user voice in it. The user has rights. The user can challenge. The user can object. The user can ask for their personal data to be deleted, erased, for example. The product safety model is not at all like that. The product safety model says we want manufacturers to get their system right and shove it on the market, right? You don't need to talk to users to do that. The user knows less about the dishwasher than the manufacturer. That is not true of AI. In AI, if we're trying to get rid of, say, bias and discrimination and structural discrimination, the Siri was a very good example. The bias there was partly coming from the fact that they were only implementing it on poor people, right? They weren't implementing it on rich people. They were using partial data sets, etc. So we need to have the voice of the user in there. I would argue at the beginning in deciding what's high risk, in the middle, in getting involved in the standard setting process, and particularly at the end in being able to complain and challenge, because that is what's made the GDPR work in as far as it works. But those rights are just not there in the current setup, in the current AI Act. It just doesn't really cognose the end user at all. And as I've already said, the enforcement is terrible because we have a system that's mainly based on self-certification and very patchy post-market enforcement. So, you know, last thing I'll say, okay, I've got one more slide, but I can come to it in questions maybe. What solutions are there to this? This is trying to look at just a couple of solutions, and you can already see how complicated it's getting. So what we have right now is AI systems, which if they are deemed to be high risk, i.e. in one of those buckets of risk, I don't know if you can see my cursor, you end up going to try to self-certify against the essential requirements. What I've been saying is, wouldn't it be nice if we had a preliminary stage where there's a criteria-based and challengeable, reviewable assessment of what's high risk, or indeed unacceptable risk, or indeed minimal risk, right? You know, why is content moderation in minimal risk when we know that it's creating vast impacts on, you know, democracy, for example, a big social value? If we had that, should we not also, because it is not the same thing, have a real algorithmic impact assessment that looks forward to the risks and brings in users to talk about their risks and brings in users from marginalized groups? Shouldn't we be talking about alternatives? Do we really need this AI system? Wouldn't it have been better to have kept our 400 human workers in the MIDAS system? You know, is it efficient? You know, if you look at a lot of the COVID tech that's been rolled out during the pandemic, it doesn't work very well. You know, did we really want those systems? Is it sustainable? You know, what about energy use? What about rare earth use? And as I've said, what about structural, not just individual harms? So these are practically all values which just don't fit anywhere in the AI Act model right now, which, you know, you could argue are really crucially important. But if we put both of those in before you even get to the point that you decide you're high risk and you still have to go and do all the essential requirements certification, and, you know, maybe we need third-party audits on one or all of these, because if they're self-assessed, you know, people will say, well, I'm not high risk, right? you know, and then they'll just go straight onto market. Maybe I am very cynical. Then you end up with this immensely complicated and very onerous system that every AI system has to go through before getting on market. And at this point, you know, the market-based people will just go, this will just restrict innovation, and the EU will fall behind the US and China, and it will never work, right? So that's the balance and the problem, okay? One solution a little bit might be to say, let's define AI systems more narrowly. That's quite popular. So maybe we should just be talking about machine learning systems here, because that's where the literature has highlighted, you know, the black box effect, the opacity, the lack of transparency, the use of data that has historic bias, et cetera, right? But again, as has just been highlighted, actually what we're finding in the public sector is legacy systems, rule-based, decision tree-based, which are having these terrible effects on human beings, you know, like Siri, right? Which, as I understand it, is primarily an old-fashioned decision tree system. So that doesn't seem that great a solution either. So I don't really have a solution, okay? That's my last thoughts is, are we agonizing too much on this, right? Is AI a concept at all? Should we actually be worrying this much? AI is snake oil a lot of the time. Should we just think about regulating data-driven technologies by sector? You know, by, for example, by labor, by performance management, by governmental allocation of benefits. So, and there I will stop. And I'll stop screen sharing.
Okay. Thanks, Lilian, for this lovely presentation. Very, very interesting. I suppose we can move to our third presenter this morning, which is Thierry TUOT. Thierry is a conseiller d'État. We were talking before on how to define a conseiller d'État in English, which is a judge of the Supreme Administrative Court. I did, and he's chairing a commission of this court, which is expected to advise the government and the president in France about issues related to AI and topics of this type. So Thierry, you have the floor. Once again, 30 minutes. Thanks.
Thank you very much, Alexis. And it's quite difficult to take the floor after two brilliant presentations, but I'll try to be clear. I have nothing to share except my experience, of course, but no screen to share. The question which has been raised by the Prime Minister and asked to the Conseil d'État is what to do about AI now, given the fact that the AI regulation, which Lilian was talking a few minutes ago, will have to wait for at least 3 or 5 years before it is implemented in national legislation. And we can wait for this time to use and deploy AI in French administration. So we have to have a strategy, and we strongly believe that this strategy needs new rules in the ethic field. Of course, some people say that the GDPR gives all answers to the question of using AI, but it can't possibly be, as has been demonstrated previously before by Lilian and Doaa as well, because in GDPR, we are dealing only with personal data, and AI is not dealing only in personal data. That's the main difference between the two regulation, and we need to anticipate on that. Some people say that as far as AI is not dealing with personal data, it's not dangerous. Let's just think of a refugee who is talking to the French or British administration with an AI translation device. The way this device is used, its parameters, its efficiency, is a question of life and death, and it's not dealing with personal data. It's just an artifact used to translate. So we need some ethic rules on AI, and we need them the more because all the guarantees given by GDPR are, to speak frankly, not working. Transparency and accountability and all the guarantees given by GDPR are written in GDPR can be upheld in court, but in fact have no efficiency or a very small one. Take, for example, transparency. You may ask in France to court to allow you to see what is in an AI system, whatever it is, and you'll be given 60 pages of mathematical writing, which is wholly useless for any user because you can't understand what it is and what is its use and what its goals. And what we are trying to devise in the report we'll be giving to the Prime Minister in the spring is a kind of efficiency, which is a material and real efficiency of the guarantees given by the French law and the French government to the users of artificial intelligence. Because we strongly believe that if guarantees are not given before starting to implement AI, there will be no AI at all. There would be a kind of revolution or a refusal, and you know that in France, revolution can be quite bloody. And we need to give guarantees to build up confidence in the fact that AI is something useful, not to the government, but to the users of AI, to the administrative people, before deploying AI. If we don't build this confidence, it will be impossible to use it, and it will be, from our point of view, a catastrophe, because the private sector is using AI. If the public sector is not using it, we'll be lagging behind, we'll be in this enforcement gap, which has been demonstrated by many analysts. The fact that we won't be able, for example, for tax or for competition, to understand what people are doing and how they are building their private firm strategy if we don't use AI. We'll be less efficient and will give less to the users. We think, in fact, that the users should be put in a position to ask for a right to AI and a right to be treated by AI rather than only by the classical administration. AI, provided it has strong ethics rules governing the way it is delivered. And in fact, we don't use the word AI, we usually use the expression AI system. AI is a way to make people believe that a kind of God power will be governing the way the administration and even our life are conducted. It's not the case at all. We only have some minor tools which are here to help people to take administrative decision. It's nothing more, nothing less. It's very useful. It's only systems and tools and subordinated tools, and not at all this great power which is hanging over us, and that Mr. Musk and others are fearing will be taking the power of God instead of God. So what do we need? I'll take the three main topics which were the subject of a roundtable. The first one is transparency. Transparency, of course, should be not only something which is given when the system is deployed, but all along the life of the system. It should be dynamic right, and not only the fact that when you ask for something, you are delivered something which is brute material without any explanation, but it should be rather truthfulness. That's to say, an explanation of what is taking place, and just not showing, but explaining what is taking place. That is a true basis for explicability. And in fact, transparency and explicability should be seen as two linked notions, transparency being the basis for delivering explicability. It's not only transparency on facts, but also on intents and ways of devising the system. That's to say that transparency shouldn't be just, you ask me how it is built, here are the photography of cables and bolts and whatever is inside the machine, but it should be what is I intending to do, how I devise the system, what kind of data set I used, where I found them, how I used them, what hypotheses I made on the fact that using those data rather than others, I would have some results and so on. That's to say, transparency, including the transparency on the content of the machine, not only in the picture of the system, but for every pixel of the picture, where it comes from, what is in true consistency, and why it is used at this place. For example, it's something on which Doaa insisted for the learning data. There should be a real transparency, not only on what are the data, which is the way that transparency is understood so far, but why those data have been chosen. Where do they come from? What is the status? Who are the people who created them? And how were they trained to create them? If we want to fight against bias and all the sexual or racial bias which AI is enhancing each time it is deployed, we need to have a transparency, which is a contextual transparency and a social transparency, as well as a legal or material transparency. Given this real transparency, which is very different from the transparency we have so far in the GDPR, we could have explicability and a real explicability as well. That's to say, not this marketing message. We believe that you have some rights to understand what we are doing with your things, so please say yes at the end of 8 pages of minor characters explanation. We believe in a real material explanation of what is taking place given to the average citizen, who is not necessarily someone with a master of law or artificial intelligence science. So we need not only what is in AI, an explanation of how it was made, but how it is working, understandable by the common man in the street. And we need an explanation of the way the AI comes to a conclusion. That's to say, what are the rules governing it, the rules which have been used to select the data and the way of building the reasoning, including the role that people in charge of the system do not understand what is taking place. Explainability is also accepting to explain that we don't understand what is taking place. And we shouldn't ask to an AI system more than we are asking to a human administrator. If a doctor is telling you, I think that my diagnosis is that you have such or such infection, we don't ask him, explain the way you have been thinking of it. So we shouldn't ask it to the machine, but we should be able to ask to the doctor who decided to use the machine, why did you use it? How did you ask the machine to function so that it comes to this conclusion and not another one? Where is the data coming from? How do you control it? And explain me the way you don't understand what it is doing. That's a true explanation, which is a cooperation between the user and the administration, and a true transparency on the motives of the way the decision is taken. This should include as well a right to follow up. When you have had an explanation of how the system is working, you should have the right to get an explanation on how it has been working on you and how it has been working on other people. And you should have this right not only at the time of the decision or the indication or the result or suggestion of the machine, but also 1 year, 2 years, 3 years after. So as to understand the way the system has been treating you and giving a right to understand what is happening with this system. The third notion was accountability. We may view it as something very classical. If you have an AI, for example, in medical screening of medical data, liability of the product is the same, whether you have a classical mechanical device or an AI device. It's no different. And you may sue for liability the people who use the system, who have been the builder of the system, who took part in introducing data in the system, in maintaining it, whatever. It's not very different from complex system as a plane or a car. If you have an accident, and product liability is a very classical one. The problem, in fact, is not product liability, but process liability. It's the fact that if the result of the process included artificial intelligence, then difficulties start. And what I think is really important is to have a principle, which is it's forbidden to say that AI is responsible of whatever result which arrive. It's always to be the service or the man in the service who is to be liable to the decision. The real implication of human supervision is not that humans should take the place of AI or be an alternative to AI or be always in a position to do something instead of AI. Is that man is always liable to answer for the result of a process, even if it includes some AI. So that the complexity of AI is not exported on the user, but it's not the internal problem of the administration. Administration cannot escape its liability by saying it's not me, the machine. It's the computer, as we have been hearing for the past 40 years. The responsibility is always the responsibility of the state, or it should be always the responsibility of the state. And so we are thinking of devising a special liability with a presumption of responsibility for the service when the service feels that AI is responsible for damage, whatever the damage, wrong decision, wrong diagnosis, wrong orientation. Then if the service is intending to say that AI is responsible, it should be the service who should be responsible, and indemnification should be automatic by a special administrative fund, and then, only then, the service could try to sue for liability the builder of the machine or people who had a role in programmation or whatever, but not the user. That would be a very strong guarantee in favor of deploying AI, because all people would know that if AI is going wrong, they will be indemnified, and with no discussion on the fact that the administration is responsible for AI. It's of course something very new and which will need much political discussion to be implemented, but which is, I think, very important. So you see that those principles should receive a real attention to become efficient and materially guaranteed. But of course, asserting principles is not enough. Effectiveness needs to tackle other issues. First issue which has to be treated so that those principles should be implemented with efficiency is to abandon the fact that all the rights are individual rights. We have built a system with the GDPR where in 6 billion people in the world, it's always one people against the whole system, against Facebook, against the state, against Amazon, against whatever. It's only one people. And so, as you all know, we are always in agreement with the fact that our personal data will be treated and used by Facebook, Amazon, or all the other ones. And this guarantee is no more guarantee, because all our data, personal data, is used by the private sector or sometimes by the public sector, but above by the private sector, with our consent, so that this consent is not guaranteed. And when you see what the private sector is able to do with our personal data, you realize that the real danger is there. What we need is to create collective rights in the field of protection of personal data. Collective rights mean a collective approach with NGO, which play a strategic role in the decision and in the delivering of the guarantees. But creating these NGOs is a work for the state. We need impartial NGOs. We need competent NGOs, not only militant one. We need the militant one as well. But to exercise collective rights, we need new NGOs with competence, and this competence should be given by the state. We need formation, we need qualification, and we need money so that NGOs, independent and impartial NGOs, will be in a position to have their own expertise, which will be a counter expertise to the state expertise or to private expertise. That's something very important for us, to think of a social control, which is no more the individual, but a collective control. The second issue we have to tackle is that so far, at least in France, the public administration are really, really supervised and controlled with legal statutes and controls and laws and decrees and controlled by the judge, which does not exist for the private sector. And the public administration, above all in the field of research, is a kind of Gulliver chained by many constraints of legal nature, which prevents the public sector, which gives all the guarantees to do what it is doing in the general interest. And what we are thinking of is that in the field of research, there should be a kind of privilege for the public-owned sector, first of all, in the field of research, and above all in medical research, so that there should be a presumption of legal conformity of the AI deployed by the public sector, which would be in a position to lead research actions, above all in the medical data sector, with a presumption of conformity and maybe some less constraints on the way it is working. Third issue we have to tackle is that we have to acclimate a new administrative culture of cooperating with the public rather than administering everything in the Napoleonic way. The unilateral approach, which was in favor in French administration before, we think that AI is in a position, if the guarantees are given, to help the administration to be in a much more cooperative mood. Given the fact that all the repetitive tasks, which have no value added to the way the administration is working, should be delegated to artificial intelligence, much more civil servants should be dedicated to the contact with the public. And although most critics feel that AI will lead to a dehumanized administration, it could be exactly the contrary. A humanized administration, because all the civil servants will be working with the public, helped by the accessory, which is an artificial intelligence system, and so being able to explain, to account, to be liable to the way the decisions are taken by direct contact with the users. And that's a new way of thinking about AI, not as a threat, but as a real asset, given the fact that this confidence built on ethics has been given before, which could really be the real revolution of AI, not something coming directly from Terminator, but something much more in a Rousseauist way of seeing the future. So maybe AI, if the ethics guarantees are given, could be something which be on the path of a new state, more democratic, because more human. And given the lessons of the past revolution, it's not really a utopia. It could be a new way of devising democratic way of managing together the state. That'll be my final word. Thank you for listening.
Okay, thanks Thierry for this presentation and this discussion. I will now give the floor to Olivia, which is going to play the role of animating the discussion. Olivia, you have the floor for the first questions. I have some also in mind, so please.
Okay, thank you very much. So first of all, I would like to thank every contributor for their very stimulating and interesting presentation. I think we have a very good overview of what is done at the moment, for instance, with the Doaa presentation, and we have seen that algorithmic decision systems are not a silver bullet, and that we need to have that you really need to have a legal framework. We have seen also that with Lilian that it is maybe a good thing to have a European legal framework, and I appreciate all your very personal comments about the state of the EU Commission proposal of a regulation. And we have seen also with President TUOT that we need to have at the moment now something some kind of ethical principle that can that can enter in force now, because this regulation will take time. And I also see some common point in your presentation that all of you have be very you have show that the devil is in the details, and that is a very complex topic. And you have also put emphasis between on the distinction between the private and the public sector, and the need to give to the public sector some means, but also to have some guarantee of the use of this technology by the private sector. Saying that, I think that the last common point is about your worries and your concern. And I think that if you are here, we have all the same concern. Is about the place of the individual, because the promise is to have a very human-centric AI, and we need to work on that. So saying that, I think that the presentation of Doaa is very interesting, because it's a comparative approach, and we have seen the differences between the United States and the European system. And I wonder if what could be the methodology, and why we do not have a lot of the development of more empirical research on the topic, and especially in Europe. I wonder if you have an idea about that, of if you think that maybe we as a researcher, we need to have more mobilization or more methodology to build some comparative research on the topic, because we really need to see how it really works on the praxis. Regarding for Lilian, I have a question. You speak about the position of the Commission, and we know that the regulation will take time to be and will be amended a lot. I agree with you that we have a very industrial centric approach from the Commission. You have told about the position, first position of the Conseil. I wonder if you think that maybe it could change this very industry focused approach on the products, or it will be only amend the focus, but not change radically the approach. That was my question for Lilian, and my question for President TUOT is how to, I was very interested about the fourth principle you mentioned, and I am very interested about the collective rights approach you mentioned, and the need to have NGO. Maybe could you give more details about that? Thank you very much.
Shall I go?
Yes, please.
Yeah, very interesting question. I'm just picking up here the report, the progress report from the Slovenian presidency. Sadly, I am a cynic, okay? It was very nice to hear the optimistic ideas about democracy and so forth from the last speaker. But I think it's going to be what I call tinkering around the edges. You know, it's going to be detailed and positive tinkering around the edges, but I cannot see them moving away from the model we have right now of high-risk AI and essential requirements and technical standards. It is possible we might move away from the largely self-certification model, though I think that will be very contested, you know, on grounds of cost and time. The European Data Protection Supervisor and quite a lot of civil society are backing the introduction of some kind of third-party audit at that point, whether it's by the state notified bodies or whether it's by some other private market. But yeah, the more fundamental changes that I've been suggesting, and I've really been wrestling with this over the last couple of months because I'm in a position of trying to practically represent an NGO myself, not exactly a civil society body, called the Ada Lovelace Institute, which is working in the UK, and I am half seconded to them to try and work on this, is how far can you make suggestions that will be seen as blue skies and basically ejected from the process. So in a way, I'm in the middle of trying to make my own thoughts into A, blue skies, and B, concrete proposals we can do to make the AI Act better. And yeah, I do think that the draft council proposal, which I am told is already not as liberal as it could be because it didn't involve the German government, because we had no new German government at that time. And now we have the new German government and it is more liberal. You know, the council position may push towards a more rights-oriented approach still. So this is all quite positive. But the biggest change I think they made that surprised me was in that list of prohibited systems at the top that I talked about, of which there's only about 4. One of them is social scoring, Chinese style social credit scoring, which doesn't, I think, occur in any European country, in fact. So it's a bit of an empty guarantee, that. But what the council has said is that should also apply to private sector social credit scoring. Now, that is terribly interesting because depending on how you interpret it, it could include algorithmic profiling and targeting. You know, it could include the whole business model of the internet. I think that is unlikely to happen because the general impression I have, and I'm not a Brussels insider, is that Brussels thinks that those problems are being dealt with within the Digital Market Initiative, within the DSA and the DMA, and it doesn't need to be covered in the AI Act. But that to me was quite a radical proposal to move to a private sector social scoring being included as a prohibited practice. I really can't see that happening. But overall, no, I don't see a change in the basic structure of the Act.
May I continue?
Yes, Thierry.
Thank you very much. First of all, I do agree with Lilian that the project of AI regulation won't change. It will be lingering for 5 years in the Parliament, in discussion in the Council, and at the end it will be nearly the same. Maybe 1 or 2 articles will be changed, but much more not at all. Neither this regulation nor GDPR. It's useless to hope for a modification of GDPR as well. It's too early. There won't be a consensus on that. But I would add, never mind. It gives us a room of maneuver, which is a huge one. This regulation is very detailed, 82 articles, but in fact, most of the important issues are not in this regulation. And it's up to the state to take the initiative and up to the society to take the initiative. So to answer the question of Olivia, which is a very good one, yes, of course, the European research is far behind the American one in the field of AI. Not on the technical field, we are among the best, but on the legal, social, and sociological, and above all, philosophical field. When you give a look at the bibliography in this field, all the interrogation on ethics and morals and organization of political system come from the US. And it's very, 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 very poor. It's only on the singularity and what can we do if Terminator is entering the room? Should we fire him or put in the programmation some good values? I mean, it's just bullshit. We don't need that. What we need is a new reflection and a ground one on the real problem. I just take an example, the data. What is a data? Can we own a data? We have all been living on the presupposition that we can be a proprietor of data and it can be sold or given or lent. And if not, what if data was a part of our own identity? What if it was unappropriable? And you see that in this field, in this way of thinking, there's a matter for philosophy first and public debate in the democratic sense before writing any law, whether hard or soft. We need this reflection. And of course, we call for, from the French administration, for development of the AI studies, including all human sciences and not only art sciences. We need everyone on board, and we need huge reflection on this matter, which is really something fundamental. So I think I will be asking that of the French government, that we need funding this matter and to start multidisciplinary and multinational research on AI. As far as NGO go, to answer the last question of Olivier, what we are thinking that if the user is not in the room where the AI is devised, the AI won't live because the people won't accept it. So we have to find a way to build kind of balls of administration of AI system, either on a territory or in a firm or an hospital or university or whatever, a ball of AI, which should be one composed for one of itself by users. And these users should have a right of say on the way it is devised, the way it is deployed, on the control, should be able to provide alternative expertise on the way it is used, and be able to account for the general public on the way AI has been devised and used. It's a whole way of thinking anew the way of administration, but it's really something necessary if we want to really deploy AI.
Okay, thanks. The other Thierry asked for the floor. May I remind everybody when, after he talked, to put down the hand. Thanks. Thierry.
Okay, thank you. Okay, do you hear me?
Yes.
Yeah. I'd like to react to the presentations. First of all, concerning Doaa's presentation, I wonder if there has been in the US other experiences than in the Michigan in terms of detection of fraud. And in this case, is there some evidence that other systems could have performed better than the MIDAS system? So that's a question. And a comment. When you raised the issue of how to integrate in the algorithm the expertise of 400 employees, it made me think at what happened in France in a similar domain, in similar field, in the field of family benefits by the Caisse nationale d'assurance familiale, and the legal provisions are highly complex because there are general rules, exceptions, exception to exceptions. There's a new kind of family, and so on. And so the law includes interpretation by the courts, through jurisprudence, but also internal interpretation by the entity itself. And no one knows which interpretation is encapsulated in the algorithm implemented to detect the fraud to the social familial benefits. So there's kind of black box of what law is inside the algorithm. I now turn to Lilian. Thank you for your presentation and your very, very rich insights into this IA Act, which is ongoing. I had a concern with the internal checking you referred to about the conformity issue. And I wonder if there's something in the European law which guarantees the independence and impartiality of the body with who could make an assessment of the technology. I had a third question, but I'll skip it for now to not be too long. Thank you.
Yeah, hi. Oops.
Okay, Lilian, you have the floor. Thanks.
Okay.
Thierry, remember to, that's it.
Okay. Yeah, it's a great question, but the thing is that although when you look at it to start with, you think that there is going to be a body that's assessing whether conformity actually happened, you know, whether the certification was accurate. That doesn't happen. There is this body called a notified body, right? If you looked at that chart, which is actually by Ronald Leans at Tilburg, it's not by me. The notified bodies are meant to be appointed by notifying, what is it? State supervisory authorities of some kind. And presumably, I haven't even checked it very carefully, presumably there are some guarantees of independence and accountability of those notified bodies who are likely to be the usual suspects. They're likely to be private providers of the usual, you know, multinational generic type, you know, whether that's VeriSign or Capital or Palantir or whoever, I don't know. But the truth is it doesn't matter. Forgive me, because if you look at the way the Act currently is, there is no need to go to a notified body unless you are essentially one of the products in the category in Annex 2, which are the existing products like toys and medical devices and cars that already have a notified body set up. So they already have it, right? It is working quite well there from what I hear, but it's not going to be there for all of the important systems in Annex 3, you know, the welfare benefit systems and the automated hiring systems and all the rest of it. So there's no question of guarantees of independence and accountability because there's no certifying body. You know, what there is at the end of the cycle is this thing called a market surveillance authority, which is going to be, again, a state-appointed body, which may well be dumped on the existing data protection authorities, who already are going under and don't have enough money and enough technical resources. So that's going to work well. And the actual supervision that they exert is really small. I mean, again, without going into the detail, which goes on for pages, it's pretty sporadic. It's not like a data protection authority. They don't receive complaints from individuals. They don't instruct representative actions. They don't do any of the things an ombudsman might. One of my vague suggestions is, why don't we have an EU level ombudsman for this that could take complaints from individuals and civil society and could also perform a constitutive role, that's probably not the right word, across the EU, in that they could gather the information and look for patterns and take super complaints, right? So I was really, really, really interested in Thierry's idea from France of having bodies that would represent the collective interest rather than just the individual interest, and that would be professionalized, right? That it wouldn't be left to civil society and NGOs who don't have any money. And I think that's a tremendous idea. It does remind me of one thing the UK does have, which works quite well in our internal consumer law, which is we have something called a super complaint designation, where we do designate a couple of organizations who are private but are well respected, like Which, who are a big consumer authority, and we give them special rights to bring consumer complaints in court and, you know, instruct representative actions and so forth. And I wonder if that's the same kind of idea. So I'm sorry, I'm just moving away from your point a little, but yeah, there is this vacuum of independent, accountable enforcement mechanism within the Act. Does that help?
Okay, thanks, Lilian. I had...
Can I also answer the question that was faced to me? Or?
Yeah, Doaa has a question.
No, I didn't have a question.
No, you have a question to answer.
Yeah, if that's okay. No, I wanted to answer Thierry's question about the other examples from the Michigan, and I think, yeah, there are unfortunately not that much better. There have been a lot of lawsuits regarding the system used also for the food stamps, the system that gives food stamps to individuals. I mean, I think there are cases, systems that work reasonably well. Unfortunately, then they don't, you know, reach the media enough to hear about them. Interestingly, in the Netherlands, there have been an attempt to do something similar to Siri, but for tax, particularly for taxing like rich individuals who have like business and using really like a high income. And this one has been stopped even before it reached the stage of being actually used. So it was like blocked in the early stages. So that really takes me, you know, to the report I was talking about with the reporter, the UN rapporteur, that how it's just always much easier to implement those systems, you know, on the population that is harder to object. And thank you for the French example. That brings me also back to the question of Valerie for the actual comparative research that is not done enough and why it's not done enough. I think it's hard to do comparative research when the regulatory systems are so different. And that's one thing, like when on one hand you have no regulation, on the other hand you have a state that continent that's trying to regulate a lot. And also the main one is also because there are not a lot of details about those systems. Like the reason why it was easier to find details about Midas and Siri is because they reached the courts. So you have a bit more like transparency in this regard. So the solution for that, I think, really connects me to the presentation of President Thierry for the putting responsibility on the state and the revealing this information and you know, being in charge of regulating this domain. So for a second, I will just put my, you know, academic hat and on the side and use my UNESCO hat to really state that this is the right way to go for, is by, you know, instating transparency requirements so that researcher can actually do their job and reveal those issues.
Thanks, Doaa, for Olivia and
Yes.
Lilian, you want to say something?
Yes, I will come back to the question of liability because I think it is a very important issue. And I wonder if some of you are aware about the follow-up of the proposal of the European Parliament, because as you know, the European Parliament make a proposal of regulation on liability and for the Commission, as well as for AI. And I was very interesting about what President TUOT said about the fact that this question of liability will be included in the, I don't know how we should call it, the guidelines for the public administration. And I think it's a good thing, because I was very surprised that in the European Commission, there are no position of liability, which is something very important for the stakeholders. So do someone have an idea of what is going on the European Commission level about liability and AI?
Okay, Lilian.
Well, I do a bit. We've started to look at Ada Lovelace, actually, and it is interesting because we're finding that civil society in general don't know very much about it, though they realize it's important. So yeah, there is this process going on of trying to transform a product liability model into one that is appropriate for AI. I think to me, the most interesting possibility is, let's see if I can get this right, is that currently the idea is you've moved from fault-based liability to liability that is not exactly strict, but where all you have to prove if you're the consumer affected is a defect and causality to the damage caused to the consumer, right? So you've got away from proving fault, negligence, etc., which is something, okay? However, with AI, it's really, really difficult to prove that causality. And it's also quite hard to prove the defect, yeah? So there is this idea, because it's black box, all that stuff, there is this idea of having a reversal of the presumption. So essentially you're presuming that the AI project is defective, and it's up to the provider of the AI product, you know, say Google, whoever, to prove that it wasn't defective, yeah? So that's one idea that's on the table, right? Then there is another idea, which I'm not sure if it is on the table yet, but I've heard people talking about, which is that this could be used as a carrot with which to incentivize actual decent self-certification according to the essential requirements. Because it could be that if you show that you did in good faith and with due diligence go through the essential requirements and mitigate your risk and do all the right things, then you might get the benefit of the presumption being put back where it was, right? So it leaves the consumer to have to prove that there was a defect and that there was causality, right? You get me? You know, and I can see problems with that as I say it, but it does strike me as quite positive within the constraints of the AI Act in giving a really good carrot or stick, depending how you look at it, to make people self-conform in a real meaningful way. Okay, so that's my main concern in it.
Okay, thanks, Lilian, for your talk. I think we are reaching the end of this.
Antoine will have a question. Sorry, President.
Hello, everybody. It was quite interesting. Just a few words from a public law standpoint. In fact, there is a kind of exemplarity of the use of artificial intelligence by public service. So there will be a kind of outreach, anyway, of this use. A concrete outreach, for instance, public procurement of algorithms by public administration should have an influence because it's an important part of the market, and the requirement which will be asked by administration for the procurement in these matters will have a great importance. Concerning the law of liability, in fact, it's very interesting to see that the European Parliament wants a civil responsibility on the provider. But on the other hand, for administration, I will have this discussion because I have the honor of being in the commission presided over by Thierry TUOT. We will have certainly a discussion about no-fault liability or equivalent liabilities for the public administration. Third, perhaps it's a too public law reaction. It's very important that we got public independent bodies, regulatory bodies, to oversight these things. And these public regulatory bodies should have indeed, because it's in their legitimacy, participation of user on the different stakeholders. And first, and five item, and then I finished, it's the importance of soft law. I'm not obsessed by soft law, but it's important because private and public soft law is an answer, maybe a kind of answer to, it would be controlled by the judiciary at the end, and anyway, we'll have soft law and soft ethics about artificial intelligence. So to be the more concrete possible, as Thierry TUOT stressed, it's very important that the use of intelligent artificial gets a real legitimacy, a real efficient action, because we are going to use it, but not in any way. And if it's not accepted, if it's not in a dialogism perspective, that won't work anyway. There will be big problems. So just so you know, and very, very thanks you very much for the very, very interesting scrutiny of the problems here that we deal with. Thank you very much.
Okay, I am afraid that we are reaching the end of this very lovely session and discussion. As President Thierry suggests, it's not the end of the discussion, but the start of further discussions. We will be very happy to do that. I would like to thank everybody for the speakers and all people attending the session for the discussion. And before we leave, I suppose Thierry now, as organizer, would like to say 2 final words about the whole workshop. So Thierry, you have the floor, and thanks from my side.
Yeah. Thank you, Alexis. Just a few words before closing this workshop. So on behalf of the steering committee, so Olivia, Virginie, Céline, Alexis, Antoine, and Jamal, I warmly thank the contributor for the wonderful presentations. We'll keep in touch with you, the contributors, about the possible follow-up of the workshops in the coming time. I want to thank you also the audience and special thanks to Céline Bégy for her precious assistance in the organization of the workshops. Thank you to all of us, and it was a pleasure to have you here during this workshop. And I hope that we'll have the opportunity to interact in the future. Thank you very much, and have a good day.
Thank you. Goodbye to all.
Bye, everybody.
Thank you very much, all of you, and especially thanks for Thierry for the organization.